and Senator Jaffer, I wasn't sure I was going to speak to this bill in its current incarnation. After all, I have made my arguments in this chamber more than once. The blinkered adoption of mandatory minimum sentences in our criminal code ties the hands of our judges. It forces them to impose one-size-fits-all sentences without nuance, nor mercy, nor common sense. This approach often robs them of discretion and imagination and flexibility. A mandatory sentencing rubric undermines judicial independence and, in the worst cases, reduces judges to little more than rubber stamps, humanoid algorithms who have to impose a penalty without any reference to the specific facts of a specific case or a specific circumstance of a specific offender. Beyond that, the threat of mandatory minimum sentences often frighten people into accepting plea deals rather than fighting their cases in court, for fear that they might receive an especially heavy sentence should they lose. These sentences distort our criminal justice system and undermine public faith in the impartiality and independence of our courts. So, having said all that, and having said it more than once, why did I decide I needed to speak to this bill in its most current iteration? It's primarily because I wanted to update you all on the case of Helen Naslund, the Alberta woman whose story I first told you in this chamber back in November of 2020. To remind anyone who has forgotten, or to bring up to date those who weren't here when I last spoke, Helen Naslund was a farm wife who lived near Holden, Alberta. She'd endured a lifetime of physical, mental, and economic abuse at the hands of her husband, Miles, a violent drunk who held Helen a virtual prisoner on their failing family farm. On a September night in 2011, after an evening of violence and threats, Miles finally passed out, and Helen Naslund, pushed to the end of her endurance, in fear of what might happen next, got a .22 revolver and put a bullet in the back of his head. Then, with the help of one of her sons, she weighed down and hid the body in a nearby slough. It took years before neighborhood gossip gave the RCMP the tip they needed to find the body. The Crown charged Helen Naslund with first-degree murder, the mandatory minimum sentence, life in prison with no parole consideration for at least 25 years. Given Naslund's age, that might literally have been a life sentence and a death sentence. And so, on the advice of her lawyer and with the agreement of the Crown prosecutor, Helen Naslund pled guilty to manslaughter and accepted a sentence of 18 years, one of the longest ever for manslaughter in the wake of domestic abuse. Now, she might have been able to advance a legitimate argument at trial that she acted in self-defense, or that she acted in a moment of extreme emotional disturbance and was perhaps not criminally responsible for her actions. But faced with the very real prospect of spending the rest of her life behind bars, she took the deal, poor though it was. Mrs. Naslund was sentenced in October of 2020, and her case immediately provoked outrage from women's groups, legal academics, retired judges, and social activists from across the country and around the world. She even attracted advocates and supporters from as far away as Afghanistan. Could Helen Naslund appeal her sentence? Well, it wouldn't be easy. After all, it had been agreed to by the judge, the Crown, and by her own lawyer, and by the defendant herself. The test to overturn a sentence agreed to by all such parties is extremely strict, for obvious reasons. A sentence must not just be deemed demonstrably unfit, but rather so, quote, unacceptably harsh, that the sentencing judge's agreement to accept it would not only be contrary to the public interest, but would bring the administration of justice itself into disrepute. And more than that, a defendant has only 30 days to appeal a sentence, and those 30 days had passed. Our own Senator Pate played a key role in helping Helen Naslund win an unusual extension of the appeal period, and in connecting her with one of Edmonton's fiercest and most effective criminal defense lawyers, Mona Duckett. Just last month, the Alberta Court of Appeal, in a 2-1 ruling, found in favor of Helen Naslund and cut her sentence in half. Madam Justice Sheila Greckle, writing for the majority, found that the sentence was so, quote, unhinged from the circumstances of the crime that it could give reasonable observers the impression that the proper functioning of the justice system had broken down. Moreover, Madam Justice Greckle found that the risk of a mandatory minimum sentence had created a power imbalance that had led to what she called a coercive bargain, which gave the Crown further leverage to extract a guilty plea. Madam Justice Greckle continued, quote, a woman subjected to 27 years of egregious abuse may be accustomed to seeing herself as worthy only of harsh punishment. That does not mean the justice system should follow suit. Helen Naslund is still in prison, but she will at least be eligible for parole next year. Thanks to the hard work of advocates from across the world, including Senator Pate, This one abused wife from a rural Alberta farm has just now received some measure of justice. But the Naslund case should lay bare some of the fundamental problems with mandatory minimum sentences, which can themselves become unhinged from the facts of the case and leave reasonable observers and reasonable Canadians with a well-founded belief that the proper functioning of the justice system has indeed broken down. What is the point of having judges? What is the point of talking about the principles of judicial independence if we do not trust judges to listen to the facts, weigh the evidence, consider all the circumstances, and justly apply the law? In a free and fair democracy, the judiciary should not be controlled by government edict, and neither MPs nor senators should be micromanaging our courts. If we want our judges to administer impartial, thoughtful justice, we can't backseat drive from behind the bench. So today, I stand again with my friends Senator Jaffer and Senator Pate. And today, I stand with judges and justices across Canada who share an awesome and solemn responsibility. Let us restore public confidence in our courts, remove the partisan politics from sentencing, and let those whom we've asked to sit in judgment use their own best judgment when circumstances require. Thank you, merci, and hi.
Sénateur Boisvenu, vous avez une question?
Oui.
Senator, Simons, would you take a question?
Absolument, madame.
Merci beaucoup. D'abord, merci pour votre discours sur ce projet de loi-là. Je suis toujours renversé lorsque vous tentez de justifier l'abolition des sentences minimales, de prendre toujours des cas extrêmes. Moi, je vais vous donner des données qui sont à date par rapport au Québec. Entre 2015 et 2019, le nombre de sentences à domicile a augmenté de 22 %. Entre 2020 et 2021, 5 047 criminels, plutôt que d'avoir des sentences de week-end, ce qu'on appelle des sentences discontinuées, ont eu des sentences à domicile. Alors, comment pouvez-vous affirmer que notre système de justice ne laisse pas une liberté aux juges d'assouplir les sentences dans des cas pas particuliers, mais généraux?
Senator Simons.
Thank you very much for that question, Senator Boisvenu. In the case of house arrest, these are obviously not cases that have those sorts of strict mandatory minimum sentences. House arrest can be an extremely effective way of handling low-risk offenders in the community and helping those offenders to reintegrate and to become functional parts of society again. They have their use and their place. In the case of first-degree murder, there would never be such a sentence.
Senator Boisvenu.
Dernière question, si elle veut accepter.
Senator Simons.
Bien sûr.
Senator Boisvenu.
Sénatrice, pouvez-vous nous fournir en cette Chambre le nombre de demandes de révision de dossiers judiciaires et le pourcentage de ces dossiers-là qui ont vu leur sentence réduite, soit par la Cour d'appel ou par un autre cour?
Simons.
I'm so sorry, Senator Boisvenu. I have no capacity to answer that question in such granular detail at this point. I simply don't have access to that data up to date at the moment.